The governor's role in approving a bill. Can the governor override the decision of the legislative house? Under what circumstances does the president step in? The Tamil Nadu Assembly once again adopted a bill on exemption of NEET exam that was earlier written by Governor Arun Ravi. The governor returned the bill stating that it was against the interests of rural and poor students. So the Tamil Nadu Assembly once again adopted a bill that was earlier written by the Governor R.N. Ravi. The bill seeks to grant exemption from the mandatory National Entrance Cum Eligibility Test NEET for seats allotted by the government in undergraduate medical and dental courses in Tamil Nadu. Last week, the governor returned the bill contending that it was against the interests of rural and poor students. So what comes next? There is no doubt that the governor will now have to grant his assent to the bill under Article 200 of the Constitution, which deals with the grant of assent to the bills passed by the Assembly. The first proviso enables the governor to return a bill. This is not a money bill with a message requesting the House or Houses. If there is an upper chamber to reconsider the bill or any provisions and also consider introducing amendments, he may recommend. The House will have to reconsider as suggested if the bill is passed. So in the present case, the bill will have to be sent to the President for his assent as it enacted under the entry of concurrent list of the subject that was covered by the central law. So if the bill is passed again with or without changes and presented for assent, the governor shall not withhold assent therefrom. So in the present case, the bill will have to be sent to the President for his assent as enacted under the entry of the concurrent list on the subject that is covered by the central law. NEET is mandatory under Section 10D of Indian Medical Council of India Act, an amendment introduced in 2016. Therefore, the state law can be enforced only if the President grants his assent. This will cause a repugnancy between the center and state laws. So what is governor's function in passing a bill? Under Article 200, the governor may grant his assent, withhold his assent, and also return for reconsideration by the legislature or reserve for the consideration of the President any bill passed by the state legislature and also presented to him for assent. So there is no particular time frame fixed for the Constitution for any of these functions. The Constitution makes it mandatory that the governor should reserve the President consideration if, in his opinion, a phrase that means he exercises his own discretion in his bill. So a bill that so derogates from the powers of High Court as it endanger the position which that court is by this Constitution designated to be filled. In other words, a bill that seems to clips the wings of the High Court or undermine its functioning will not become a law without the President's assent. So what happened when the President considers the bill? So once again, there is no particular time frame. Article 201 says that when a bill is resolved by the governor for his consideration, the President shall declare either that he assents to the bill or that he withholds assent therefrom. He may also direct the governor to return the bill if it is not a money bill or the legislative along with a message. So the House or Houses will have to reconsider the bill within the period of 6 months from receiving it. It may pass that the bill again with or without any change, the bill shall again be presented to the President for their consideration. So the article ends with that. This means that the bill will become a law if the assent is given, but nothing can be done if the bill is denied assent by the President or he can make no decisions. Does the governor have any discretion in this regard? Section 75 of Government of India Act 1935 contained the words "in his discretion" while referring to the governor's grant of assent to the bills. The phrase was consciously omitted when Article 175 in the draft constitution, later renumbered as the present Article 200, which was enacted. So commentators generally agree that the governor, who normally functions on the aid and advice of the Council of Ministers, is bound to go by the advice in the matter of granting assent. It may be unusual. Also, it seems somewhat unusual when the governor should act on a ministerial advice even when withholding assent and returning the bill for reconsideration. However, a reading of the Constituent Assembly debates shows that this was indeed what the framers of the Constitution intended. It also explained on behalf of the drafting committee that there may be a situation when the Council of Ministers feels that the bill has been hastily adopted or that it requires any changes. In such a situation, the Constitution must provide for the possibility of the Council may want to recall its bill and accordingly advise the Governor to return it. While analyzing the provisions, the Sarkari Commission and the Union-State Relations points out that the constitutional advisors said that there could be occasions for even withholding assent on the advice of the ministers. For instance, if after the bill is passed, the ministers resign before the bill gets Governor's assent, the new ministry may not want to go ahead with the bill and also might advise against assent being given. So these examples suggest that no decision or discretion was even envisaged by the Governor in dealing with such bills. So this is regarding the Governor's role in approving a bill. Can the Governor override the decision on the legislative houses? Under what circumstances does the President can step in?